Hello and welcome to this special show, Regulating Realty. Good evening, I'm Mentara Rai. Today is 1st of May and today is the day that India is supposed to get its real estate regulator across the country. But all the states have still not notified the Real Estate Act, the Real Estate Regulator Act, which is aimed at bringing in transparency. Builders are busy upgrading businesses for the new regime of stricter regulatory supervision across the country. What we endeavor to ask all our experts over the next 30 minutes is there going to be more bureaucracy? Are buyers' interests indeed protected by the Real Estate Regulator Act? What else needs to be introduced to ensure that buyers don't have to keep facing the problem of delayed possession? Remember, it's a double sword whammy. Not only do they put in money and wait for delayed possession, but on the other hand, they also play the home loan rates as well as rental for the current accommodation. As of now, not more than 12 states, that's including the likes of Gujarat, Madhya Pradesh, Rajasthan, have notified the rules. We are still waiting for India to meet its date with the Real Estate Regulator Act. It was supposed to happen on 1st of May, and it does seem as if that deadline is indeed going to be missed. But what all do you, the buyers, need to keep in mind? Let's bring in our panel of experts. Rajeev Talwar, he's the Group Executive Director, he's actually the CEO of DLF. He's also the top boss of the real estate developers body Naradco. We are also joined by Niranjan, Hiranandani. He's going to be representing the builders from Maharashtra in particular. Hitesh, Jain, the partner at ALMT Legal, as well as Niraj, Kumar, the partner at DSK Legal. Good evening, gentlemen. Thank you so much for joining us here on ET Now. Niranjan, Hiranandani, I'm going to come to you first. States had ample time to notify the real estate regulator. We had seen the centre notify the rules. It's been over a year. However, this 1st May deadline is being missed by most of the states. So my question is this indicative of things to come, of the spirit behind RERA being lost?
It appears that many of the states are going to be missing it, but I am located in Mumbai, where the regulator is already fully put into place. Mr. Devendra Fadnavis has put this regulator online, and Mr. Gautam Chatterjee has been appointed as the first regulator for under RERA. This is going to be fully online. Nobody has to take a hard copy to the regulator, and it will be operational on May 1st. However, May 1st being a holiday, obviously it will be operational from May 2nd. So they are expecting, and the regulator states that it is going to be seamlessly operating.
Mr. Hiranandani, you're saying it's not a big deal, it's just a matter of a few days. I want to show that map of India that we were just showing to our viewers. I want to show it on a full screen. I'm going to ask my producers to do that. And as you'll be able to see on this map, it's just a few states that have actually notified the Real Estate Regulator Act, and most of them are BJP states or states that are have allies with the BJP. What you're also seeing in yellow are the draft rules. The red is where the rules have been notified. The green is the let my producer show you where the green comes. The green are the only states which have notified the regulator. Rajeev Talwar, we just heard Niranjan Hiranandani saying the states missing the deadline is not a big deal. What is your expectation from RERA? I'm not just asking you as the CEO of DLF, I'm also asking you as the head of Naradco.
Well, we are hoping that with the onset of RERA, first of all, the interest of buyers, which has prompted the government to legislate this act, will be protected. And number two, that yes, RERA authority itself in every state will lay down the guidelines on how to cut timelines, probably how to introduce online registrations and online approvals, and thereby eventually make it a less cumbersome process, but all the same regulated, but not unduly over-licensed. So let's hope that this is how it will pan out over a few years' time.
Rajeev Talwar, we are also seeing dilution by states. So it's not just about missing of the deadline. For example, let's bring up Haryana. It's a BJP government where the ML Khattar government has decided to dilute provisions of RERA. I'm talking about Haryana, which also incidentally is in DLF's backyard. How are consumers' interests being protected? The one that you just spoke about, consumer activism, consumer protection, if the states are not going to play ball?
I don't think they've diluted the provisions as yet, and or there is any such intention to do so. But yes, I think one thing which we need to place firmly is that RERA should protect the interest of the buyers even in the past, which means that those who have bought apartments or properties should be delivered those as early as possible. I think that if the intention of the authorities is to do just that and allow each individual case to be examined and then to give time, sufficient time to complete the projects and hand them over to the buyers at the original price, I think that would go a long way in removing the trust deficit and in restoring the confidence of buyers into real estate.
Niranjan, Hiranandani, let me come to you. I said at the top of the show, I brought you here to represent Maharashtra and particularly Mumbai for us. We saw protests when the Devendra Fadnavis government had attempted to dilute provisions in RERA. Is that a lesson for consumers in other states? Or has Maharashtra managed to still get away with considerable deviation from what was enacted and approved by the centre?
No, I don't think so. What had happened is there was some interim dilution which was announced, but after the protests which took place and people brought to the notice of the government that the dilutions were being done, they have reverted back and the dilutions have been completely eliminated. So now it is all in line with the central notifications, and in fact, they have made more realistic. Looking at the western region, regulations and rules are there. There are certain idiosyncrasies of the rules in Maharashtra and Mumbai, and they have tried to bring that into alignments of all the nitty-gritties and details. For example, small thing like we have occupancy certificate and a separate building completion certificate. So all those have been aligned and things like that have been brought into place. So I think what they've tried to do is, while keeping the idealism of the central bill without any dilution, they have made certain realistic changes depending on what are the rules and regulations of approval in Maharashtra, in Mumbai and the entire region. So I think there's a positive impact of that, and it has definitely pro-consumer at the end of the day.
Okay, so these are the two. You're saying it's pro-consumer. That's exactly what Mr. Talwar said. In fact, he said there is no dilution by the states. Let's get a legal perspective in on this. Hitesh, Jain, I'm going to come to you first. You've heard what the two builders on the show have had to say. I know your links with the BJP government, yet I'm going to ask you to put on your lawyer hat. What are the kind of dilutions we've seen? And if we are seeing dilution in provisions by the states, what is it that consumers must keep in mind?
From the perspective of the buyers, they need not worry, because I don't see people going towards the court also to make sure that the state fall into the lines. In the last month itself, I think as far as Haryana is mentioned, I'm sure when the draft, these are the draft rules, but the final rules that are circulated, you will see the interest of the buyers being protected. When the Maharashtra state also, there were a lot of concerns that were expressed when the draft rules were framed, but ultimately when you see the new regulations, they are balanced one, and they protect the interest of both the buyers and also the developers. So the balance has been achieved. So I'm sure in the other states where they are not falling into the line, I think the central government is very keen, and the central government will make sure that the rules are in line with the intent that has been expressed in the act.
Niraj, Kumar, let me come to you now. You've heard what the other three panelists have had to say. Do you agree with them that the provisions have not been diluted? We've heard very different news reports and in fact seen it in the fine print. And I'm talking about states like Haryana with the draft rules. Uttar Pradesh has done so as well. Gujarat has done it. That's a BJP government as well. Whereas Odisha and Bihar seem to have pretty much copy-pasted what was enacted by the centre.
Well, in my view, Nayantara, one has to look at the first of all the broad objective of the enactment. The objective of the enactment is to ensure fair play and to ensure the to safeguard the interest of the buyers. Now, in light of that, the Parent Act, the Act basically lays down the broad guidelines. What kind of project should be falling within the RERA purview and things like that. So, what tantamounts to dilution or what doesn't tantamount to dilution needs to be examined at a more granular level. For example, if you look at the draft rules of Uttar Pradesh, where everybody was saying that it has been diluted to a certain extent as far as the ongoing projects are concerned. So, the Parent Act says that any project where the completion certificate has not been obtained should be governed by RERA, whereas the rule says where the builder has submitted for the obtaining the OC or the CC, whatever the case is. In that case, that will not be seen as an ongoing project. Now, per se, this is should not be seen as an absolute dilution of the provision, but what has to be seen is if a builder who has actually paid the dues of the authority and has made an application for the occupancy certificate and that has been stuck in some bureaucratic issue, then if that is the intent of that rules and that to keep these projects out of the purview, that should not be seen per se as dilution of the provision. But in case the idea is that even where somebody has surreptitiously made an application for obtaining an occupancy certificate, whereas the builder has not yet paid the dues of the authority, and that being the right reason why completion has not been obtained, in such a scenario it can be called a dilution. So, from case to case basis and depending upon facts and circumstances of the particular case, it can be said whether it is a dilution or not.
That's exactly what Niranjan Hiranandani said, that in Maharashtra you've seen some idiosyncrasies that have been ironed out with the deviations from the Central Act. Hitesh, Jain, you come in here now. What kind of dilution have we seen by the states? And you know, I mean, we've covered that, but what I want to also ask you, what Niraj Kumar talked about, is that our ongoing projects, is there absolute clarity on that front, that unless there is a completion certificate in place, previous projects as projects with retrospective effect will be covered under RERA? There's absolute clarity on that front?
Well, yes, most of the state where they have framed the rules, it's been very clear in the rules that the ongoing projects are also covered, except one caveat where the completion certificate has been issued prior to the commencement of the act, commencement of the rules, that is 1st May 2017, the cutoff date. Those projects are not covered, but all the ongoing projects where the completion certificate has not been issued, they will be covered by this act. And the projects where the completion certificate has been issued, now once the CC has been issued, the developer should be in a position to grant the possession also to the buyers. So, in a way, it's a very good, the rules are very clear that all the ongoing projects where the completion certificates are not been issued will be all covered by the RERA.
Okay, so that's you know, we seem to have unanimity there as far as the two lawyers on our panel go, that ongoing projects are going to be covered. And the way Niraj Kumar pointed out, it's fine to have dilutions by the states if it means idiosyncrasies are sorted out. As something Niranjan Hiranandani also spoke about. Rajeev, Talwar, you're also going to have to put 70% of the buyer's advance now in an escrow account, in a separate account. The clear idea being builders often divert funds to expand, they divert to other projects, to buy land, to announce new projects, etc. But on the flip side, it means that builders like you and Mr. Hiranandani and all others will lose fungibility of money. When you lose fungibility of money, is that going to mean you're going to pass that added cost to the buyers? Should consumers brace for prices going up?
Actually, I think we'll have to see a changing world in real estate in India. A lot of buyers have had problems, and a lot of builders and developers are facing problems because of the equity provided by the buyers when they buy properties at the time of a launch. First of all, we are going to see a certain time lag in between the launch and the purchase of a property by the developer himself, because all approvals are required before you can file for registration into RERA authorities and thereafter sales. I think a lot of prudent builders will have to change their way of working and complete the structure or even complete the apartments before selling. This would not mean any increase in prices, which is wrongly being stated so, because every market and every property has a price which is at a fair market price at any given point of time. It is the time you choose. For instance, in the earlier system, when people used to buy at the time of a launch or a pre-launch, they very often sold or resold properties while they were being constructed, and if there was a price rise, or definitely when the properties were to be handed over after completion. So everyone was playing the game at the market rates, and I think the same should continue. After all, the market will only determine what is the rate of a property at any given point of time. After getting all the approvals, after beginning the construction, it is for the developer to select at what time will he launch the property for sale. And I think that would be a fair beginning. But if people can change their way of working, take institutional finance, build in all the inflation which comes in during construction, and launch at the
Sorry to interrupt you, Mr. Talwar. Sorry to interrupt you. I get all of this, that, banking system, banks have to behave differently, financial institutions will have to think differently about financing real estate. I get all of that. My pointed question to you is, will this act, will RERA be inflationary in nature because builders like you will lose fungibility of money? Will property prices go up? And we're talking at a time when the property market is as dead as it can be.
Why should they? It's a market price. It's not higher or lower price. That's what I'm trying to explain. That it is neither a lower price because it is sold at the time of launches, or a higher price if it is sold after completion of the structure or completion of the apartment. It is all a market regulated price. It is neither higher nor lower than anything earlier or later. And there is the builder will have to plan his finances, will have to plan his cash flows, and thereafter, in any case, launch only after the approvals are there. So I don't think in the real estate world, there has ever been a lower price or a higher price. These are all fairly market determined prices.
Okay, so you're saying that there should be no impact on pricing. Niranjan, Hiranandani, do you agree with Rajeev, Talwar that we're not going to see much of an impact, that builders may not have to hike prices even though they lose fungibility of money?
That's absolutely correct, Nayantara. The amount of escrowing that is required to be done in terms of 70% is going to remove fungibility. It will protect the buyer of the new tenements which are there and the money that he's investing, and so it is a buyer friendly scheme. But at the end of the side, those builders who are already stuck in terms of credit not being available for existing, seeing that fungibility is a big issue. So I think the transition part of it is going to be difficult for many of the builders who are already having difficulty in terms of credit upliftment. So Nayantara, yes, the answer is that there is going to be a lot of problems for those developers which are already stressed, because now under the new scheme you cannot transfer monies from the new schemes where builders will be starting to old schemes where they are already stuck with the inadequate credit. So yes, there will be a problem, but that's a transition phase. And I think whenever you start new laws and regulations, a transition phase will have to be overcome by industry. And yes, it's going to be a pain for many people who are stressed. And this pain is not going to be easy to overcome, especially where credit is not there. Second, I think we'll have to see how the banking system works, because ultimately at the end of the day, the banking system also has to get confident of how this RERA is going to function in view of the escrowing of the amount. But yeah, the overall system over a period of time will become much better.
You know, we've already discussed whether prices will go up or not. And Niraj, I don't know about you, I felt that Mr. Talwar and Niranjan, Hiranandani are not on the same page on that one. I want to come to you and ask you now legally about the protection provided to buyers with respect to delayed possession. We have seen in this act, at least by the central government, saying there's going to be an interest penalty of 2% added to whatever the current price of SBI's base rate is. Right now it's 8%, so you're talking about a penalty interest of 10%. That is what is supposed to deter builders from delaying possession. Niraj, do you think buyers' interests are indeed protected when it comes to delayed possession in this act?
So, Nantara, you have to look that percentage from a different perspective as well, because the buyer has two options. One is to seek refund of the whole money, or to look for this penal interest that he is entitled to in case of delayed possession. So, in a market where a buyer has come in, after which the prices are tanked, for example, and the developer has defaulted, then at least the buyer has the option of exiting the project altogether. So, which is a very, very good provision as far as the buyer is concerned, though I don't think this is an equitable provision for the developers, because both developer as well as buyers have some stake in the project, and in case of a macroeconomic scenario, the prices have gone down. Either of the parties should not have a inequitable advantage. But given that what it is, I think the provision of the act basically is buyer friendly, and buyers should be happy about it.
Hitesh, Jain, let me come to you now. I want to get your legal perspective in as well. We have also seen a lot of buyers seek redressal, for example, the Competition Commission of India, which is not naturally a platform you would assume buyers to go to against builders. They've complained about buyer agreements being one-sided, builder-buyer agreements being one-sided, how they've had to pay, let's say, an 18% penalty in case they are late by a monthly installment, whereas a builder is only given 5 rupees a square foot, even if a project is delayed by up to 7 years. Do you think RERA has successfully created a level playing field between builders and buyers?
Well, as far as the interest is concerned and the 18%, I think this is the thing of the past. The developer has to also register the agreement with the regulatory authority. The rules in the agreement clearly provides as to what is the interest for the delayed payment he can levy, and what is the compensation he has to provide in case of delay to the buyer correspondingly. So both the issues have been addressed both by the act and the rules, and those are very clear. So I think levying of 18% interest and all these one-sided allotment letters are clearly going to be things of the past. The regulatory authority will be all the information will be uploaded on the website, including the terms of the agreement and the allotment letter. All the provisions will be uploaded to the regulatory authorities, and the regulatory authorities will have access to all the information, and the consumer will also have a valuable right to approach the regulator in case the developer is insisting on any unfair terms in the agreement. So all those aspects are concerned. The buyer is completely protected under the new regime.
Okay, so buyer is totally protected. Rajeev, Talwar, builders like you will also have to change the way you quote prices. As per RERA, now you have to quote as per carpet area. It's buy what you pay for, that's what you're going to get. So there can be no hidden charges from what I understand, for super areas, preference location, parking, etc. How is this going to pan out?
I think everyone knows that the future of housing and real estate will mean high-rise and multi-rise apartments. They have to be given parking in basements, which is expensive. Similarly, every builder will try to make a difference in the super area, in the entrances, in the other facilities given. But yes, as it was done earlier on the super area, now it will be on the carpet area. So I don't think anyone will have any problem in dealing with this. It is what facilities you provide, and therefore the new paradigm which will come over a few years will be to see what you buy and thereby sell apartments more and more in quantity post completion. There may be a certain percentage which is sold at launch. There may be a certain percentage which goes during construction. But by and large, people would give you the best valuation after the project is complete and ready to be handed over.
You're going to buy what you get, and that's going to be the prices that will have to be quoted. Niraj, we're running out of time, so I'm going to give my final question to you. This is an act that talks about imprisonment when it comes to errant builders. Do you think the government missed an opportunity of also bringing in municipalities, state departments, central government departments under the ambit of RERA? Because unless that happens, you're not guaranteed timely approvals, and that alleged Babu builder nexus cannot be broken. So do you think this has been a missed opportunity? Does RERA indeed have the teeth that all the consumers are banking on?
Nayantara, I will tend to agree with you that is a slightly missed opportunity, because timely delivery of a project by a developer is not a function which is entirely controlled by the developer himself. He is subject to certain approvals, etc., which is within the realm of bureaucracy. So if the authority would have been or the different departments of government which are actually giving these approvals, they were made amenable to the jurisdiction of RERA, it would have been much better, because in equity I don't think the developer should be penalized in case he is doing his bit but is not able to deliver on time on account of, say, defects or defaults on the part of the authorities whom they have to get the approvals and the sanctions. So yes, it's slightly missed opportunity,
okay,
but it's not too late. One can always look at actually bringing out the necessary amendments and rectifying this.
In fact, I think Maharashtra has tried to do that with different provisions in different acts. That could be a lesson for other state governments as well. Gentlemen, we're totally running out of time, so we have to wrap up our special discussion on regulating realty. Thank you very much for joining us here on ET Now. It's 1st of May. All the states should have notified a real estate regulator. Perhaps in the days to come, those that have not will be doing so. And let's just hope that the states play ball and they don't dilute all the provisions as enacted by the Parliament. Many thanks for watching this special.
Find us on Facebook at facebook.com/etnow and don't forget to click the like button. You can also follow us on Twitter at etnowlive. To stay updated with all our programming, hit the subscribe button on our YouTube channel by logging on to youtube.com/etnow.